Okay, welcome back, everybody. Hope you had a good hot drink. I had some lovely hot chocolate from Starbucks just there around the corner there. Okay, so before the break, I said I'll talk to you about the assignment. I'm not sure when your assignment is due, because I've lost track of the dates. But anyway, perhaps, here you go, 23rd of March. Where are we? Yeah, so you've got, okay, but there are two questions. One is on contract law, the other one's on tort law. Okay, so we'll cover all the material, no problem with that. I think the first question is on formation of a contract. Okay. Leave the message. Morning, buy the car for that. This morning. Have you seen an email? Not had a chance reading. Just yes. Okay. So it looks like it's the one on. Well, we'll go through the. The principles we covered in the first one or two lectures. Remember, with regard to formation of a contract, the court will look for essential elements in the formation of a contract. That's how you start off your answer. Okay. Yeah, okay. And the second question looks like is on private nuisance, which we'll cover in the tort part of the course. All right. With regard to the contract question, you're asked to advise somebody whether there's a contract between him and the other person. So everybody, you'll be glad you came. I'll give you the oh no, that's gone. Come back again. I'll give you the perfect way to start off your answer to that. Hang on, keeps going away. So whoever it is would like to know if there's a contract between him and the other person. Full stop. Perfect way to start off. Next sentence, everybody. The court will look for essential elements in the formation of any contract. The court will look for essential elements in the formation of a contract. Full stop. You know what they are. Agreement, consideration, intention to create legal relations, certainty, and no illegality. Okay, full stop. The only element an issue in your assignment question 1 is the element of agreement. Ta-da! Full stop. Next sentence. You know the next sentence, don't you? If not, I'll be very disappointed. The Gibson Principle. The court will analyze the existence of agreements in terms of offer and acceptance unless there are exceptional circumstances. Okay, House of Lords, Gibson, full stop. If you cite Gibson, you'll probably pass that question. If you don't cite Gibson, good luck, okay? Because that sets up the rest of your answer, and you should then have subheadings. Is there an offer? Question mark. Has it been communicated to the offeree? Is there acceptance? Question mark. Has that been communicated to the offeror? Or has the offer been withdrawn? Okay? And so revocation of an offer is one of the key issues here. What about revocation by email? Well, I've given you a PowerPoint on that. Remember, the courts will not apply the postal rule to email. And so the courts will say that email will be affected when it is, quote, received, unquote. What do you mean by received is a good question. Does that mean actually being read by the person it's sent to, or whether it's actually received by their machine? The courts are not clear, so you can use your magic 2-letter word, if. Okay, good. So that's how you handle your first question. Don't panic if you can't come to a black and white conclusion. As long as you can identify the issues, and you identify the issues by applying your questions and explaining your applying your definition, and explaining your principles, okay, and then apply to the facts, arguing both sides. Okay, so that's how you handle question 1. Always start off, the court will look for essential elements in the formation of a contract. Oh, that would be a second sentence. The first sentence would be, whoever it is, I haven't got his name, would like to know if there's a contract between him and the other person. Full stop. Next sentence, the court will look for essential elements in the formation of a contract, colon, agreement, consideration, etc. Full stop. The only element an issue in our question will be the element of agreement, and cite the Gibson Principle. Next sentence, there will be no exceptional circumstances in your assignment question 1, full stop. There will be no exceptional circumstances, and therefore you look for offer. Has it been communicated to the offeree? Look for acceptance. Has it been communicated to the offeror, or has the offer been withdrawn before acceptance? They are the key issues. And with regard to email, remember the postal rule does not apply to email. Okay. And I've given you a PowerPoint on that, which on email, when it's actually effective. As I say, the cases are not definitive. Is it when it's actually read by the person the message is sent to, or whether it's actually received by the machine? The court is a little bit unclear, but that doesn't matter. Remember, in some areas, the law is a little bit unclear, and so perhaps we need a good higher level decision, or perhaps even legislation. Okay, so that's question 1. Question 2, we won't be able to, you won't be able to do that till we cover private nuisance, which is second major tort when we get to the tort part of the course. Which sort of reminds us, today's what, lecture 6. So today, of course, we're still on contract law. On Thursday, we're still on contract law. Saturday, we're still on contract law, but maybe an introductory look at tort law on Saturday. Okay, and the 2 major torts we look at are the torts of negligence and private nuisance. There is another type of nuisance called public nuisance. Negligence obviously must know. Private nuisance must know. Public nuisance should know, bordering on must know, in that sometimes public nuisance is relevant to exam questions by way of contrast with private nuisance. Okay, so more about that later. Right, so what about the assignment then? You've got your deadline, don't be late. Also, with regard to your assignment, what's your presentation? Highlight your cases and statutes, and the best way, of course, because you're typing it, is put them in bold print. No need to underline them, just put them in bold print. Also, you should bold any subheadings you might have. Also, start each question on a new page. This seems a bit commonsensical, if you like. Make sure it's clear to the person who's marking your paper what question you are answering. Then you might say, well, of course, but you would be surprised at the number of papers I've marked in which I wasn't quite clear what question are they answering. Okay. So make sure you make it clear. Start each question on a new page and make sure you number it correctly. Now, the word limit is generous. Don't worry. You don't have to go right up to the maximum word limit as long as you stay relevant to the issues. Don't repeat the question. Now, a lot of students put in their assignment and they include the question. I don't want the question. We want the answer to the question. Okay, you've already got the question somewhere else. So in your actual assignment, what you actually hand in, don't hand in the question, hand in the answer to the question. Okay, and don't worry if you don't go near the maximum word limit because it's very generous. Okay. And it's amazing the number of students saying word count, 1,999, whatever it is, right up. Okay, do put in your word count because you're not supposed to go over the limit. I mean, no way you need to go over the word limit. Okay. Also, no need for footnotes or bibliography. Some teachers do want footnotes or bibliography. No need to put that in your assignment answer. If something's important, put it in the main text. Okay. Also, try to have headings, and the best subheadings are issues. Okay, so in question 1, no need to cite text. No, don't need to do that. Treat this as if it's an exam question. An exam question, you wouldn't have to put in text citations. Certainly put in case names, absolutely, and put in legislation if it's relevant. Okay, but no need to put in footnotes, no need for a bibliography, no need for any text citations. No need to put that in. Okay, good. And of course, your best headings are issues. So, I mean, in question 1, is there an offer? Question mark. Okay. Has it been communicated to the offeree? Question mark. Is there acceptance? Has it been communicated to the offeror? Or has it been withdrawn? before acceptance. So they should be the sort of subheadings you should be looking to put in your answer in question 1. Question 2 doesn't look like you really need too many subheadings. When we get to it, there is a definition of private nuisance, by the way, and question 2 is largely on private nuisance. Okay, and we'll talk about that later when we get to the taught part of the course. Single space your answers. I mean, no hard and fast rule here. If you want to double space your answer, fine. But it always reminds me of my good friend Nick Barnett, who was a High Court judge, one of my friends, when I was studying law. And he said, whenever you are in court giving an argument sort of thing, it's always better to keep things more compact and spread them out. The more you spread things out, the harder it is to focus on them. Okay, so to that end, I think it's preferable that you single space your answers, but then you could perhaps leave 2 or 3 lines between paragraphs. And by the way, have paragraphs. Don't hand in an assignment with no paragraphs, or I'll start tearing my hair out and I haven't got much left anyway. Well, actually, it's all right. So have paragraphs, and no one paragraph should be too long. I mean, if you're getting over 10 lines, you're starting to get a little bit long with paragraphs. Paragraphs are good, okay? Obviously, type your answers, and then keep your paragraphs and your sentences relatively short, okay? If you read Lord Denning, when he gives a judgment, if you read any of the late Lord Denning's judgments, he was renowned for having pretty short sentences. And the reason is, the shorter your sentence, the less likely there is going to be confusion, okay? And I always, so if in doubt, keep it shorter. So if you have a sentence which starts off talking about one issue but then gets sidetracked into another issue, you might find that you're going backwards and forwards between 1 and 2 issues, and then you're not quite sure whether you're on issue 1 or issue 2, whatever it is, and then you keep going on and on and on. You get totally lost and confused. The person reading your text gives up, okay? So structure is important. Obviously, it's more important what you actually write, but how you structure your answer, everybody, shows you how clear a thinker you are. And so you should have structure in your answer. Structure means have subheadings, keep your paragraphs relatively short, have paragraphs, keep your sentences relatively short, okay? Good. And I think that's probably it. If you've got any general questions on the assignment, then drop me a line in the chat box. And I haven't actually given you a copy of this PowerPoint, so I mean, take a picture if you like, and bear that in mind when you're doing your assignment. And remember, with question 1 of the assignment, you start off, whoever it is, would like to know if there's a contract between him and the other person, full stop. Next sentence, the court will look for essential elements in the formation of a contract, full stop, colon, agreement, consideration, etc., full stop. The only element in issue in your question will be the element of agreement. Then you cite Gibson. You know the Gibson Principle, don't you? Don't you? Shouldn't have to remind you. You should have the Gibson Principle written down somewhere, burned into your brain. The court will analyze the existence of agreement. By the way, it's existence of agreement, not contract. Existence of agreement in terms of offer and acceptance, unless there are exceptional circumstances. Gibson, House of Lords. And then the next sentence would be, in your question, there are no exceptional circumstances. So then you go into that analysis. And by the way, I gave you a PowerPoint on how you answer questions dealing with where the main issue is the element of agreement. Okay, so follow that guideline in that PowerPoint I gave you right back in lecture 1. Okay, so that's question 1. And as I say, the email one is probably the, when is email effective? Good question. So the court's a little bit uncertain on this. They say email is effective on receipt, unquote. What do you mean by on receipt? Is it actual being read, or is it on receipt? On receipt by whom or what? Okay. So be prepared to use your magic 2-letter word. If it means receipt by the actual person, then what's the consequence? If not, then you go the other way. Okay. So remember your magic 2-letter word, if. Okay, so that's it for the assignment. Any questions? As I say, drop me a line, but don't be late, okay? You can do question 1 now. Question 1 you can cover all right. Question 2, of course, we can't do that till we cover private nuisance in the taught part of the course. Okay, so that's it for the assignment. I hope you found that useful. All right. Then we're going to now get on to, where are we? Termination of a contract. Okay. So here we are. So let's sort of step back a little bit. I mean, when we met for the first time, and indeed in person, it was lovely to see you all in person. Shame I can't see you all in persons now, and I haven't got my webcam on because I'm not that good to look at anyway. See no section for communication. Oh, well, there'll be communication. Okay. So, termination of contract. So when we first met, we looked at the formation of a contract. Okay, a contract was born. Now we're going to look at the death of a contract or termination of a contract. Okay, seems no section for communicate. Well, obviously an offer has to be communicated to the offeree. Okay, well, you can almost assume that's the case. And I think on the facts it's clear. See, perhaps you don't even need a subheading for that. You just say, is there an offer, question mark, and has it been communicated? So that could be a subheading. It's up to you how you choose your subheadings, but usually the best ones are issues. Okay, so how can a contract be terminated? Well, you can terminate it by a number of ways, and the methods are not mutually exclusive. The most common way of terminating a contract is by performance. So the parties perform their obligations under the contract, so the contract is terminated. So if I'm buying, I don't know, a laptop computer, I pay the money and the person gives me the computer. We have performed our obligations under the contract. Contract terminates by performance. Okay. However, there are some situations with regard to termination of performance where both parties have not performed their obligations under the contract. So we'll be looking at that shortly. Secondly, you can terminate a contract by breach, although that's technically not accurate. Breach of a contract does not terminate a contract. Acceptance of the breach terminates the contract. And that's under the general heading of repudiation and acceptance. What do you mean by repudiation? You are in breach of the contract. And so the technical term is repudiation and acceptance. So if there's breach of the contract doesn't terminate yet, but if the breach is accepted by the other party, then that will terminate the contract. The contract, though, will not terminate until there has been acceptance of the breach. But of course, as you know from our work on terms, not all terms are of equal importance. So when we talk about breach, we mean breach of a condition, or perhaps breach of an innominate term, where the other party is deprived of substantially the whole benefit of the contract. Okay, breach of a warranty will not lead to termination of a contract. Okay, it's got to be breach of a condition or perhaps an innominate term. Okay, and remember the contract doesn't terminate on the breach, it terminates on acceptance of the breach. Until the breach is accepted, the contract carries on. And you do need to be aware of, is the contract alive or dead? There is no such thing as a walking dead contract, if you know what I mean. You're either alive or you're dead. Okay? I mean, Walking Dead TV series, all right? I mean, they're alive. If you're moving, you're alive, aren't you? Anyway, it's got into season 12 or whatever it is. Anyway. Obviously, somebody likes it. Now, you can also terminate a contract by agreement, whether both parties agree. Okay, normally that's no problem. If both parties still have obligations to perform under the contract, that's no problem. There might be a problem with termination by agreement if one party has completed the obligations and the other party has not. So there might be an issue. Is there consideration for termination by agreement. Okay. Now, the unpatching, get a contract be partially alive. No, there's no such thing as a partially alive contract. It's either alive or it's dead. Okay. So there you are. It's black or white. And once you're dead, that's it. All right. And then last but not least, everybody, you can terminate a contract by frustration. And everybody, frustration is our last must-know definition. There is a definition of frustration, which I don't think we'll get onto tonight. We might just briefly. I'll tell you what it is now. Frustration occurs when, without fault of either party, a contractual obligation has become either impossible, illegal, or radically different from that which was undertaken by the contract. Okay? And frustration is raised as a defense to a claim for breach of contract. Okay? And so somebody might say, you're not performing your obligations under the contract, therefore you're in breach of contract. And you might say, yeah, I'm not performing my obligations because my obligations have now become either impossible, illegal, because the law's changed, or, and this is a slightly tricky phrase, radically different from that which was undertaken by the contract. And of course, we know what impossible is, we know what illegality is. What do you mean by radically different? Good question. We'll be looking at that a little bit later when we get to frustration. But appreciate where frustration comes in. Frustration is raised as a defense to a claim for breach of contract. Somebody's saying you're not performing your obligations under the contract, and you say, yeah, my defense is because it's impossible. Good defense. Illegal. Good defense. Or radically different. And we'll look at what radically different means when we get to it. Okay. And it is possible, right at the bottom of the screen, well, it is possible that you can terminate a contract by more than one method. Okay. I mean, that's a point to note. Okay. All right, so let's get on to termination, first of all, by performance. The most common way of terminating a contract. Both parties have performed their obligations under the contract, no problem. What happens, though, if there's partial performance of what we call an entire contract? What do you mean by an entire contract? An entire contract is, as in Cutter and Powell, a sailor working on board a ship, which says you're not going to get paid until the entire contract is completed. I mean, this seems a little bit stupid when you think about it. Why would you agree to such a term? Well, because you didn't have much bargaining power. So if you're a sailor on board a ship and the shipping company said to you, okay, your salary is £100 or whatever it is, but you will not get any of it until you complete the entire voyage. So that's called an entire contract. And so this was a problem way back in the 18th century, as illustrated in Cutter and Powell. Cutter and Powell on page 161. The defendant was the master of the ship. The defendant hired Cutter to be his second mate for 30 guineas for a voyage. Oh, not bad, back in the 18th century. The ship was called the Governor Parry, sailed from Kingston. Sounds like Johnny Depp, Pirates of the Caribbean. Oh, okay. Sailed from Kingston and arrived in the port of Liverpool on there. But Cutter was on board the ship, sailed with her 2nd of August as a second mate. Unfortunately, he died on the voyage. Okay. And obviously he can't sue because he's dead, but his wife sued as his personal representative representing his estate. And she sued for the salary that was due to her husband. And the court said, bad luck, this is an entire contract. You don't get anything until you complete the whole voyage. Sounds very tough, okay? And the widow argue, hang on, he's performed, half of the voyage, is entitled to half of his salary, or whatever it was, on a quantum meruit basis. What do you mean by quantum meruit? as much as you earn, okay, if you like, pro rata. But the court held it was a condition precedent to the payment to cutter, namely that he proceeds, continues, and does his duty as second mate in the said ship from hence to the port of Liverpool. In other words, he had to complete the voyage before he got paid anything. He didn't complete the voyage. Partial performance is not good performance. But cutter is exceptionally tough, and there are lots of exceptions to cutter on this quantum merit principle, as much as you earn. Okay, quantum means as much merit as you earn. And there are plenty of examples to it, which I should know more than must know. Section 32 of SOGO, Sale of Goods Ordinance, on page 162. You can, if you are buying goods and the supplier can only supply half of them, then you can accept part payment, whatever it is, and that's covered in the Sale of Goods Ordinance. If a seller makes defective deliveries that do not amount to a repudiation of the whole contract, and if the buyer refuses to take further deliveries after the seller's breaches, the buyer's refusal to accept further deliveries is a breach of the contract by the buyer. Okay. Oh, well, that's it. But section 32 too makes sense. Okay. If people are contracted to deliver some goods and they can only deliver half of them, then they're entitled to half of them. That's section 32 of Sale of Goods. That's basically what it says. Sorry, I was reading something else there. All right. Preventing performance. This sounds very sensible. I'm going to talk. Have I got Planche and Colburn in a separate one? No, I haven't. Okay, let's talk about Planche and Colburn on page 163. In Planche and Colburn, one party prevented the other party from performing their obligations under the contract. Well, in that case, you can claim the amount of money that you have earned, quantum merit. So in Planche and Colburn, an author was engaged to write an article to be published in a series called The Juvenile Library. This is top of page 163. Before he was able to complete his article and before any portion of it was published, the Juvenile Library was discontinued. The court held that since it was the publisher who discontinued the work, the author was prevented from specifically performing under the contract. As such, the publishers were bound to pay the author a reasonable sum for the part that he already prepared, and such reasonable sum was recovered on a quantum merit basis. I think it was pretty well half of what he was entitled to. Okay, so that makes eminent sense, doesn't it? Also, Section 33.2 of SOGO, the court can look at a contract and break it up into different parts, and then you can get paid for some of the parts. So that's severable contracts. Should know, not must know. And then a slightly more meaty situation is what we call substantial performance. And this is a matter of fact and degree in every case. And the two cases that are always contrasted here are Honig and Isaacs and Bolton and Mahadeva. Now, what is substantial performance? Good question. It really depends. Let's say a contractor has completed the job, but he hasn't done it perfectly. There are some small defects which have to be remedied. Well, in that case, the contractor can still get paid, but there could be a deduction for the defects. And that's Honig and Isaacs. The plaintiff was an interior decorator and furniture designer. The plaintiff agreed to furnish the defendant's one room flat for £750. Okay, and the terms of payment were net cash as the work proceeds, balance on completion. The defendant complained that some of the work was defective, and he only paid £400, alleged that, in fact, he was not liable to pay anything under the contract on the grounds the contract was an entire contract. The court disagreed. They said that the Court of Appeal, the contract had to be regarded as an ordinary lump sum contract, and the contract had been substantially performed. In other words, you haven't done everything perfectly, but you know, you've done pretty well everything expected of it, so you'll get something. Okay, and the court found that he was entitled to the full payment less £55, which sounds very reasonable. Okay, Bolton and Mahadeva, this is a tougher one though. Again, Bolton and Mahadeva, this was an entire contract in which you're only going to be paid right at the end, £560. My computer doesn't have the pound sign, so I've got the dollar sign. But you'll notice that the defects here are quite big, £174. The court found that this was not substantial performance. And so it was no performance at all. So in Bolton and Mahadeva, the contractor got paid nothing. All right. So, you know, what is substantial performance? Really up to the court to decide what is substantial. I mean, in Honig and Isaacs, it was just what, £55 out of 750. I mean, that's substantial performance. But, you know, 174 out of 560 court, well, that wasn't substantial. I mean, how does the court decide this? Okay, anyway. But that was the decision of the court. So even though you don't totally perform your obligations, the court can look at this in each case. It is a question of fact and degree in every case. And of course, the courts are not going to be as tough as in Cutter and Powell. If Cutter and Powell were decided today, the sailor would have got something. All right. So interesting cases, but most of them should know. If you get a question in this area in the exam on termination, you could get it in part A of the exam, just outline the different methods of terminating a contract. It could be sort of a general type question, so we don't need to go into great detail of these, but they are sort of interesting cases. All right, now the second method of terminating a contract is what we call repudiation and acceptance. And in repudiation and acceptance, it's where there's breach of either a condition or possibly an innominate term. Remember what an innominate or intermediate term is, okay? It's a term which cannot be classified as a condition or a warranty. And so the courts will look at the effect of the breach. If the innocent party is deprived of substantially the whole benefit of the contract, then the court will treat that as breach of a condition. If not, they'll treat it as breach of a warranty. Okay, so that's where there's breach. Now, of course, as I mentioned before, breach of a condition or possibly an innominate term does not terminate the contract. All it does is make it possible for the innocent party to then accept the breach. When they accept the breach, that's when the contract terminates. Okay, so it's important to note if there is breach of contract and the innocent party does nothing, the contract carries on. It is alive. Okay, and it's not just partially alive, it's alive totally. When the breach, though, is accepted, then the contract terminates. All of it terminates, not partially. Okay. Also, we need to note that there are two types of breach. One is called actual breach, and the other one is called anticipatory breach. What is the difference? Actual breach means the time for you to perform your obligations under a contract has arrived. You don't perform, you are in actual breach. Okay, good. That's reasonably straightforward. However, there is another type of breach called anticipatory breach, which means what? If a party gives advance warning that he is not going to carry out his obligations under you've signed a contract, okay? But then one of the parties says, I know I've signed a contract, but I'm telling you now, I'm not going to perform my obligations under the contract. Well, that's anticipatory breach because the time for him to perform has not arrived yet. Okay, so what can the innocent party do with an anticipatory breach? Good question. Well, you can elect to accept an anticipatory breach straight away and the contract will terminate. Or you can elect to keep the contract open and carry on. Okay, it seems a little bit silly in a way, but it is possible. And I'm going to give you a case in a moment called White and Carter and Mcgregor, which I understand is not in your course manual, but it's an interesting case. The innocent party doesn't have to accept the breach. That's the point. Okay. And if it's an anticipatory breach, what can the innocent party do? Well, you can accept the breach straight away. The contract will terminate straight away. But the problem with the innocent party, though, is that you can terminate the contract, but you may not get much in the way of damages. And so the innocent party may not want to terminate for anticipatory breach. They may want to keep the contract open, and they can do that. But are there limits on the option of the innocent party to keep the contract open when there's anticipatory breach? And the answer is yes, there are. Okay. And then, so that's the two types of breach, actual and anticipatory breach. And if there is actual breach, the innocent party must elect to accept the breach and terminate the contract. Otherwise, the contract carries on. It will be affirmed. Okay, it will carry on, which means what? Is that the innocent party will have to make sure they keep performing their obligations under the contract, or they could be in breach themselves. Okay, good. So how do you communicate your acceptance of a breach of contract? The answer is there's no particular form of acceptance. And this is illustrated by the Santa Clara case on page 170 of your course manual, also known as Vitol and Norrell. And the court said that you don't have to send them a message, hello, you're in breach and I'm accepting your breach. But I mean, in practice, you should, particularly these days where it's pretty easy to communicate. All right. So the court said as long as you, you could actually, by your actions, indicate that you are accepting the breach. Okay. And that could be sufficient communication that you have accepted your breach by your conduct. But of course, in practice, it's always wise to send it, hello, you're in breach and we're accepting it, contract terminated, and we're claiming damages. All right. So no particular form of acceptance of breach of contract, but I mean, in practice, send them a message, WhatsApp or whatever. And the important thing to note, of course, right at the bottom, as I've repeated, termination occurs on acceptance of the breach, not when the breach itself occurs. That's why termination by breach is not strictly true. The more accurate description of this method of terminating a contract is repudiation and acceptance. Repudiation means you're in breach. And remember, if you're in breach, the contract carries on until it's accepted. And bearing in mind, of course, the first point, it has to be breach of either a condition or possibly an innominate term where the effect of the breach is to deprive the innocent party of substantially the whole benefit of the contract. Okay, so that's termination by breach stroke repudiation acceptance. And then with regard to anticipatory breach and actual breach, I've given you this PowerPoint. The first point is pretty clear. We've covered this already. Actual breach is when the time for performing your obligations has passed. You haven't performed. You are in actual breach. Okay. Anticipatory breach is where the time to perform has not yet arrived, but the other party indicates it's not going to perform when required to do so. And the famous case on this, which I don't know why it's not in your course manual, you'll find it in most good textbooks, is a case called White and Carter and Mcgregor. Let me give you the facts of White and Carter and Mcgregor. Mcgregor was a painter. White and Carter were White and Carter councils. Okay, the council hired Mcgregor to do a painting job. I think it was to paint rubbish bins, and it was an entire contract. Mcgregor was not going to get paid until right at the end of the period, which I think is 2 years. So they signed an agreement under which the council promised to pay Mcgregor a certain sum of money at the end of the 2-year period, and McGregor's job was to paint rubbish bins. Well, they signed the agreement, but then the council said to McGregor, hello, I know we've got a contract, but we're telling you now we're not going to pay you. Well, obviously McGregor's not happy, and he said, was he obliged to accept the breach? No. Did he accept the breach? No. This was anticipatory breach. And so the McGregor decided he'd just carry on performing his obligations under the contract. So he kept painting the rubbish bins for 2 years. Okay. Now, there is a duty to mitigate your loss or lessen your damages when there is breach of contract. Okay. Which we should bear in mind, which we'll have a look at a little bit later. But this duty to mitigate your damages only applies where there's actual breach. Okay, it doesn't apply where there's anticipatory breach. Okay, and so McGregor didn't have to say stop, lessen his cost, reduce his damages by accepting the anticipatory breach. He simply carried on performing his obligations under the contract for the 2-year period, then claimed the money. Could he do that? The court said yes. There's no duty for him to lessen his damages until the actual breach occurs. However, this is a rather odd case, and there are limits on the White and Carter McGregor case, and the limits are that you cannot carry on performing your obligations if you require the cooperation of the other party. Also, you can't simply go on clocking up your expenses if it's unreasonable. And what is unreasonable depends on the facts of each case. It could be, that you need to perform your obligations here because it protects your reputation or whatever. Okay, so White and Carter McGregor, interesting one. If it's an anticipatory breach, the innocent party doesn't have to accept the breach straight away. Okay, they can carry on performing their obligations under the contract and then claim their sum of money right at the end. Okay, of course, we're talking about an entire contract. An entire contract is you don't get paid until right at the end. Because if you're worried about this, you perhaps can negotiate terms of a contract where you get paid in installments. So that's different. Okay. But there's no duty to mitigate or lessen your damages with anticipatory breach. This duty to reduce your damages only occurs when there's actual breach. Okay. Now, a couple of cases here, which are interesting ones. One is Avery and Bowden. Avery and Bowden on page 169. I haven't actually got this on the PowerPoint, but Avery and Bowden was an interesting case in which there was anticipatory breach, in which the defendant agreed to load cargo on a ship before the outbreak of war, before Russia and Great Britain. So the other party indicated, no, we're not going to pay you. But what happened was that the innocent party carried on performing their obligations under the contract. But then what happened? War broke out and the contract was frustrated. And we'll look at the effects of frustration later, okay? And so if you don't accept a breach, the contract carries on and certain things might happen. So in Avery and Bowden, the anticipatory breach was not accepted, and then something happened which terminated the contract anyway because there was frustration, outbreak of war. Avery and Bowden, interesting case. The other case, which is a bit more, well, it's actually in your course manual, is a case called Brace and Calder. And Brace and Calder is on page 194. 194. Just this. 194. Seems a long way away. Yeah. Yeah, Brace and Calder. My goodness. For some reason, it's on page 194, talking about mitigation of loss. In Brace and Calder, it was somebody employed by a partnership, and he was paid a certain salary. partnership was changed, and so technically he got terminated, and the partnership was in breach of contract. And so the innocent party is supposed to mitigate your loss, and he could mitigate his loss by accepting the offer to join the new partnership on exactly the same terms. Okay, so there was breach of contract, but the employee could sue for breach of contract, but the new partners were willing to employ him on exactly the same terms. He should have accepted that by mitigating his losses. Okay, so when it comes to termination of a contract by breach, remember the contract is not terminated by the breach, it's terminated by acceptance of the breach. And remember, there are two different types of breach. One is actual breach, the other one is anticipatory breach. And so if there is anticipatory breach, the innocent party doesn't have to accept it. Why wouldn't you accept an anticipatory breach straight off? The answer could be that you may get very limited, if any, damages for breach of contract. However, we will see when we get to remedies later on, a well-drafted contract often has a clause in it which is called a liquidated damages clause, which does what? It says that if there's breach of contract, the innocent party will be entitled to a certain sum of money according to either a sum of money or a formula which can be used to calculate the quantum of damages. Okay, and so if there is such a clause, then well, you should accept the breach and you claim your sum of money under this liquidated damages clause. But there may well be no such clause, and so if there's anticipatory breach, the innocent party said, well, you know, what's the point of me accepting the breach? I'll carry on, perform my obligation, then I'll sue for the entire sum. Okay, so that's what happened in White and Carter and Mcgregor. Okay, everybody, so that's termination by repudiation and acceptance. That brings us on then to termination by agreement, which is our third type of termination. But I think, everybody, it's a good time to have our second little break. Okay, welcome back everybody into the final stretch for tonight. So before the break, we started working on the different methods of terminating a contract. Remember, the most common way of terminating a contract is by performance. Okay, but remember, you can get these situations in which there is only partial performance or substantial performance. So that adds a little bit of variation to that. Then, of course, you can have termination by breach. But remember, technically, that's incorrect. It's termination by repudiation, which is breach, and acceptance of the breach. And then it's only when the acceptance is made that the contract will terminate. Okay. And of course, if you're going to accept the breach, you need to communicate your acceptance of the breach to the other party. But as we saw from the Santa Clara case, is that the courts are a little bit lenient on what this actual communication is. And in the Santa Clara case, mere failure by the innocent party to perform their obligations under the repudiated contract could be sufficient to amount to acceptance. So the fact, if one party is already in breach, the fact that you then stop performing could be sufficient to indicate your acceptance. So there's no particular form of acceptance of the breach. But in practice, of course, it's always wise to just send a clear message that you're accepting the breach, terminating the contract, and then presumably claiming damages for breach. And we'll be looking at remedies when we get to Chapter 5 of the course manual. The main remedy for breach of contract will be damages, but there are other remedies in equity, such as specific performance and an injunction. Okay, but that will be not tonight. And it'll probably be towards the end of Thursday, okay, when we get on to remedies. All right, so let's get on to the last method of terminating a contract, which is by frustration. Now, we're not going to totally finish this method of termination tonight, but we're going to get a long way. And frustration, everybody, is the last must-know definition. Remember, check your toolkits. 6 must-know definitions in the contract part of our course. Number 1, offer, you know. Acceptance, you know, because Gibson gives us those two. Then consideration, reciprocal benefit and detriment, Curry and Miser. Exemption clause, a term in a contract which seeks to exclude or restrict liability for either negligence, misrepresentation, or breach of contract. And of course, misrepresentation itself, a false statement of fact made by a party to a contract which induces the innocent party to the other party, to enter into a contract with the representor. Okay, and then of course, frustration. Now, what on earth is frustration? Well, frustration in a way, is similar to misrepresentation in that whether or not there's misrepresentation, how do you know? Well, apply your definition. Are all the elements of misrepresentation satisfied? In other words, apply the case law which looked at earlier. Was there a false? Was it a statement of fact? And was the representee induced? Okay. But the remedies for misrepresentation are in legislation. And of course, for misrepresentation, that's the misrepresentation ordinance. Similarly, with frustration, whether or not there's frustration, apply the definition, which we're about to go over. But the remedies for frustration are in legislation. And the legislation is the Law Amendment Reform Consolidation Ordinance, LARCO for short, and largely Section 16, which we'll look at probably not tonight, maybe more on Thursday. Okay. And frustration is also, in a way, similar to an exemption clause, because an exemption clause, remember, is raised as a defense to a claim for either negligence, misrep, or breach of contract. Frustration is raised as a defense too, but only for breach of contract. So appreciate where frustration fits in. It is a way of terminating a contract, yes, and you plead frustration in a court case because you're pleading it as a defense to a claim for breach of contract. You are in breach of contract, but then you raise frustration as a defense. Because what is frustration? Here's your must-know definition. Must-know, all right, looks a little bit long, but not too bad. And this is the last one. Okay, are you up to it? Frustration occurs when, without default, or simply fault, without fault of either party, and we'll look at what fault means later on, performance of a contractual obligation has become either impossible, illegal, or radically different from that which was undertaken by the contract. Okay? So you can see from that, frustration is raised as a defense to a claim for breach of contract. You're not performing your obligations under the contract because now it's impossible. Why would it be impossible? Well, maybe lack of time, it's probably, okay? Or could be illegal because the law has changed. Now, earlier tonight, I mentioned a case called Avery and Bowden. In Avery and Bowden, it was a case initially on anticipatory breach. One party is saying we're not going to perform our obligations under the contract, but the innocent party carried on performing their obligations under the contract. So the contract was kept alive, so to speak. But then war broke out. It became illegal to deal with that type of goods. And so the contract terminated by frustration. Okay, which is a good, Avery and Bowden I like because it illustrates the importance of knowing whether a contract is alive or dead. If there's anticipatory breach, which has not been accepted, the contract carries on. It is alive, okay? But that's what happened in Avery and Bowden. The innocent party kept the contract alive, but then it was terminated by frustration because an outbreak of war made these activities illegal, okay? And what is frustration? Frustration occurs when, without fault of either party, and in Avery Bowden, neither party was at fault, but war broke out. Performance of a contractual obligation then became illegal. Okay, okay, so that's frustration. Now, most of that definition comes from Lord Radcliffe in Davis, Contractors and Ferrum. Now, I say most of the definition. Before Lord Radcliffe gave his decision in that case, it was very clear that you could have frustration where the obligations have become impossible or illegal. But then Lord Radcliffe has introduced this new phrase called radically different. Now, what do you mean by radically different? Good question. The word radical actually goes to the roots of the contract, okay? And this word substance of the contract comes up again, all right? And the expression radically different, you can see what that means by looking at two cases which we're going to look at in a moment, called Krell and Henry and Herne Bay and Hutton, okay, which we're going to get to in a moment, okay? So there's your definition, everybody. It is must know. It's a little bit long, but not too bad. Frustration occurs, and it is a method of terminating a contract. Frustration occurs when, without fault of either party. Now, fault can either be negligence, it could be a deliberate act, but there are various degrees of fault, okay? So we'll look at that a little bit later. Performance of a contractual obligation has become either impossible, illegal, or radically different from that which was undertaken by the contract. Important to note, everybody, the burden of proof is on the defendant. The defendant wants to raise frustration as a defense. Therefore, the defendant has the burden of proof. If you are asserting that there is frustration, the burden of proof is on you to prove frustration. Okay, good. If you can succeed, then the contract terminates automatically. The contract is void automatically. From when? From the dates of the frustrating event. From the dates of the frustrating event. So in a way, frustration is a little bit like mistake. If there is a mistake, the contract is void from the very beginning, void ab initio. With frustration, if there is frustration, the contract is void, not from the very beginning, but from the date of the frustrating event. Okay, good. So that's frustration. What's on the screen is must know. The definition is must know, but make sure you know where frustration fits in. It's a defense to a claim for breach of contract. And if you're raising it as a defense, you've got to prove all the elements of frustration. Okay? And if you can succeed, then the contract terminates automatically. It is void, and void from the date of the frustrating event. Okay? And hang on, just checking my PowerPoints here. Where are we? Yeah, okay. A little bit more on frustration itself. Because the effects of frustration are quite drastic, the contract terminates automatically from the date of the frustrating event. The courts are reluctant to find that there is frustration. And in the Davis Contractors and Fairham case itself, which is on page 174, the courts found that there was no frustration. Okay. By the way, I've skipped over termination of a contract by agreement. Perhaps I should say a few words about that. It's on page 172. It's very short. You can terminate a contract by agreement. I better skip back a little bit back. Sorry about this. I just realised I'd skipped that bit. I'll go back and there you are. Terminated by performance. That agreement. Yeah, because I wanted to mention this. Sorry. Have I mentioned this? No, I haven't. You can terminate a contract at any time by agreement. No problem if both parties perform their obligations. But what happens if one party has completed the obligations and the other party hasn't? Then there's a question of consideration, unless you execute the termination under seal, where you don't need consideration. I just wanted to remind you of the case of Folks and Beer. Remember, Folks and Beer says part payment of a debt is not good consideration for the whole debt. But remember, there are exceptions to that. For example, payment in a different form, or earlier payment that can amount to consideration. So just a reminder about Folks and Beer. Folks and Beer, remember, gives us the must-know principle of the part payment of a debt principle. Part payment of a debt is not good consideration for the whole debt. So on page 172, under the heading 4.3, you might want to write a reminder, Folks and Beer, House of Lords. Okay, part payment of the debt is not good consideration for the whole debt, but note the exceptions to the Folks and Beer principle. Okay, sorry about that. I skipped over that. And let's go on to frustration. Okay. So with regard to frustration, everybody, don't forget the definition. And remember, the courts are reluctant to find there is frustration because the contract terminates automatically from the date of the frustrating event. And in Davis Contractors and Fairham, which is, where is it, Heidi? In Davis Contractors and Fairham on page 174, you've got the facts there. What happens is that the price of the work went up quite a lot. I think the price went up something like 40% increase in the costs. And so there was a plea for frustration. The court said no. Why not? Because it was not radically different from the obligations undertaken by the contract. What do you mean by radically different? Well, price increases, even though there might be sharp increases, are not radically different. Okay, so what do you mean by radically different? Well, it has to be something that goes right to the root of the contract. Okay, so that's Davis Contractors and Fairham. This is where Lord Ratcliffe came up with this expression, radically different. And everybody's saying, well, what do you mean by radically different? It might be, something might be different, but it may not be radically different. For example, if I had all my hair shaved off, I would look different, but I would not be radically different. Okay, so what do you mean by radically different? Good question. We'll look at some cases on that in a moment. Also, a well-drafted contract should have terms in it which anticipate certain natural events occurring, and these are what we call force majeure clauses, which is French for irresistible compulsion or coercion. And if you have a force majeure clause in a contract, such where there's a typhoon or earthquake or outbreak of war, then you follow what is in the contract. So if there is a provision in the contract covering this particular event, follow what is in the contract. That will govern when the event actually occurs, okay? And also a reminder again, with regard to frustration itself, there are two parts to it. Frustration itself is a question of the common law. Apply your definition. And if there is frustration, the contract is terminated automatically. It is void from the date of the frustrating event. But the remedies for frustration are in legislation, largely Section 16 of LARCO. Okay, so remember, you can draw a parallel between frustration and misrepresentation. I mean, they are different, but as far as the structure of an answer to a question on misrep is concerned, it is similar to the structure of an answer in an exam to a frustration question. Whether or not there's misrepresentation, apply your definition. But the remedies for misrepresentation are in legislation, the misrep ordinance. Whether or not there's frustration, apply your definition. But the remedies for frustration are in legislation. Now, I emphasize that because you will find in most contract books, they do go into remedies at common law, but these remedies have been overtaken by legislation. So when it comes to remedies for frustration or the effects of frustration, you go straight to the legislation. So, for example, there are cases in your course manual which look interesting, but they're all history. What cases am I talking about? Well, where are they? I'm looking for them. Cases like... I can't find... Where are they? Yeah, cases like on page 180. Cases like Chandler and Webster. What's the other one? Yeah, Chandler and Webster is the main one. But there are others in which the court looked at the effects of frustration at common law. And they used to say, well, losses lay where they fell, which, you know, what happens if you spent a lot of money on a contract and then the whole subject matter got destroyed? Well, bad luck. Losses lie where they fall. That was seen to be very unfair. That was seen to be very disproportionate. And so legislation was enacted to try to achieve a much fairer distribution, if you like, of losses when there was frustration. So watch out for those cases, which are effectively history. And I'm talking about cases like Chandler and Webster on page 179. There are other cases which you might find in other textbooks. So when it comes to remedies for frustration, everybody, you go straight to the legislation. Is everybody clear on that? Okay. And the legislation, section 16 of LARCO, which we may not get onto tonight, but we certainly will get onto on Thursday. Okay, so frustration is very drastic remedy. The contract is rendered void automatically from the date of the frustrating event. The courts are very reluctant to find that there is frustration. A sharp increase in price of products will not result in frustration. That's the Davis Contractors and Ferrum case, where I think the price of the products involved went up something like 40%. Well, bad luck. You should have a provision in the contract covering this. Also, if a certain event occurs, such as outbreak of war or natural events, there should be, or often is, a clause in the contract covering these type of events. And these are called the force majeure clauses. And if there is such a clause and that event occurs, you follow what is in the contract. And it may well be the wording of that clause imposes an obligation on one of the parties. They will, if you like, cop the losses if there is that event occurring. And if that's the case, then that party can take out insurance to cover any such losses. Okay? And of course, there may well be events that have not been foreseen in the contract. And this is where frustration may indeed come into being. All right. So having said that, though, frustration is a question of the common law, and we're going to look at some cases in a moment in which the court found there was frustration. And remember, if there is frustration, the contract is terminated automatically from the date of the frustrating event. But the remedies, everybody, now, you go straight to the legislation, and the legislation section 16 of LARCO. So what are these examples of frustrating events? And I think as we go through, everybody, draw up your list of must-know cases. Your first must-know case on frustration is Davis and Ferrum, because Davis and Ferrum largely gives us the definition of frustration. Okay, good. Number two must-know case on frustration is Taylor and Caldwell, which I think is on page 175 of your course manual. Is it 175 or 173? Where is Taylor and Caldwell? I think it's on page, there it is, 175. So the facts of Taylor and Caldwell. The whole subject matter of the contract was destroyed. It was in a rental agreement, including a music hall in a garden. The court held the main subject matter was the music hall. When the music hall was destroyed, I think it was by fire, the contract was considered frustrated. Okay, so where the subject matter is destroyed by fire or whatever, some event that might destroy the subject matter, that is an example of a frustrating event. Okay. Taylor and Caldwell, watch out for that, can come up in exams, okay, where the subject matter is totally destroyed, could well amount to frustration, okay? And assuming there's nothing in the contract covering this, okay? Also, it's where the subject matter is unavailable. This is where you have performing artists unable to perform because of illness, for example. Condor and Barron Knights is Barron Knights were a group of male singers, and also one of the members of the group, the drummer, got ill, and the company was the group was unable to perform because they couldn't get a replacement drummer. Okay. And of course, in Hong Kong, we've had this with the Rolling Stones back in 2003. I think they were hired to give a concert in Hong Kong, but it was cancelled because of SARS. So that would be an example of frustration. Okay, without fault of either party, their contractual obligations became impossible. Okay, and that was without fault of either party because nobody was to blame for the outbreak of SARS. So Condor and Barron Knights is an example of where the subject matter is unavailable because the performing artists are sick, and it's not their performance, they got sick. Also, Gurmerco is a very important case. Gurmerco we're going to look at a bit more detail later, but Gurmerco was a case in which a stadium was hired to give a concert, but what happened was that the stadium was in a dangerous state of repair, and so the concert was unable to go ahead, and they couldn't find an alternative venue. And the court found that there was frustration because it was impossible to find another venue for the concert in time. There was a deadline there. So Gurmerco is a good example of frustration, but Gurmerco is also one of the leading cases on the effects of frustration. And we're going to look at Gurmerco, which has a look at applying the legislation to come up with the remedies for frustration. So watch out for Gamerco. Shepherd and Jerome is a similar sort of one in which there was an artist who had to perform, couldn't perform because of illness. Okay. Also, impossibility of a stipulated method of performance. Again, that depends on the facts of a case. You've got that, can't pronounce it one, Chariglo. Chakirillo glow. Oh, goodness gracious. In Knobley Fall, those cases on page 173, in which there was impossible. It was impossible to perform their obligations under the contract. Okay, again, not to worry about too much about those two cases. Taylor and Caldwell is your must-know case. Gamerco is a must-know case. That Sakarilla Globe case is on page 173. Contract in question was a CIF contract, cost insurance and freight, under which the vendor is bound to procure the goods to be shipped by the route that is usual and customary at the date of the shipment. If there's no such route, by a reasonable route, a specific contract for the sale of those ground nuts was made at a time when the route was via the Suez Canal, but the Suez Canal was closed at the date for the shipment, and if the nuts were shipped by the much longer route by the Cape of Good Hope, there'd be 100% increase in the freightage. The vendor claimed that the contract was frustrated by the close of the Suez Canal. So was that a frustrating event? House Lords held that as long as a reasonable route remained open, the contract was not frustrated. A significant increase in the freightage was no grounds for finding the contract was frustrated. So that case illustrates it's very difficult to find frustration. A significant increase in costs is not sufficient to ground frustration. Okay? Don't worry about the other shipping cases there. They're just illustrated. The two must-know cases, which we do need to have a look at in a fair bit of detail, at the bottom of the screen, Crell and Henry, contrast Herne Bay and Hutton. Now, Crell and Henry, Herne Bay and Hutton, everybody, are must-know cases. And I'll go through the facts very briefly tonight, and we'll repeat them again on Thursday. But Crell and Henry and Herne Bay and Hutton both concerned a situation in which somebody hired, well, first of all, in Crell and Henry, they hired a hotel room. Why did they hire the hotel room? So they could view the coronation procession of Edward VII, who had just been crowned. Okay, now Edward VII got ill and the procession was cancelled. Sorry about that. Come back. Okay. Now, they hired their hotel room and they refused to pay for the hotel room in Crell and Henry, which is on page 176. So they're in breach of contract. But they raised the defense of frustration. They said, hang on, we hired this hotel room to view the coronation procession. The procession was cancelled. Therefore, this is radically different from which we entered into the contract. And the court agreed. They agreed that the main reason for the contract no longer existed. This was now radically different from which the parties had undertook the contract in the first place. Okay, so in Crell and Henry, the court found that there was frustration. Okay, your cost manual is a little bit deficient here because Crell and Henry actually went to the House of Lords, and the House of Lords held 4-3 that there was frustration. Okay, so in Crell and Henry, the contract was frustrated because the obligations under the contract had now become radically different. The court found there was only one reason for the contract, that was to view the coronation procession. By contrast, Herne Bay and Hutton, it was a contract to hire a boat to sail around a harbour and view the fireworks or naval display which was put on to celebrate the coronation of the king as well. But then the naval review was cancelled because of the king's illness. And so the parties who hired the boat refused to pay. They were in breach of contract. So they were sued for breach of contract, but they raised the defense of frustration. Frustration occurs when, without fault of either party, well, neither party was at fault, their obligations became impossible, illegal, or radically different. So were their obligations radically different? The court said in Herne Bay and Hutton, not radically different. What you started off with was a contract to sail around the harbour and view the Royal Navy review. What did you end up with? A contract to sail around the harbour. Different? Yes. Radically different? No. So, in Herne Bay and Hutton, there was no frustration. In Crell and Henry, there was frustration. So how do you reconcile these two cases? Well, some people say in Crell and Henry there was only one main objective, to view the coronation procession, and that was no longer existing. By contrast, in Herne Bay and Hutton, you could argue there were two objectives: one, a boat trip around the harbour, and two, view the coronation procession. Okay, but they are two cases on reasonably similar facts, but with opposite conclusions. So Crell and Henry contrast Herne Bay and Hutton, and in Crell and Henry there was frustration. Herne Bay and Hutton, there was no frustration. Everybody thinks, though, that Crell and Henry, they were lucky. Remember, if you're alleging frustration, you've got to prove it. And for some reason, they were able to satisfy the court that the main reason to hire the hotel room was to view the coronation procession. But why do you hire a hotel room? Don't you use the washroom or whatever? Okay, and so everybody thinks in Crell and Henry they're very lucky. But remember, it's House of Lords decision, despite what your course manual says, is actually House of Lords. And it's a split decision, 4-3, okay? And so the court found there was frustration, okay? I think it's because in those times the British were very much pro-monarchy. I mean, the Brits still liked their queen, but back in the early 20th century, and Crell and Henry's, 1903, the Brits were even more pro-monarchy. And you say, why would you hire a hotel room? Oh, to see the procession of our beloved king. And the fact that it's a hotel room is irrelevant. It's just that that gives us a good viewing angle on the coronation procession. And of course, that's the whole reason for hiring the room. The fact that you're using the washroom is incidental. So Crell and Henry, they were lucky. But it does illustrate what on earth radically different means. Radically different means it goes to the root or foundation of the contract. So the defendant was able to prove frustration in Crell and Henry, failed to prove it in Herne Bay and Hutton. So Crell and Henry, there was frustration. In Herne Bay and Hutton, there was no frustration. Okay, so good cases, and the must-know cases for your purposes, because they could come up in exams. So far on frustration, everybody, check your must-know case list. Number 1, Davis and Fairham, which gives us the definition of frustration. Number 2, Taylor and Caldwell, because you could get a situation where the subject matter is totally destroyed without fault of either party. Gummerko is a must-know case, but more on the remedies for frustration, which we'll cover not tonight, but next time. And so Gummerko is case number 3. And then I would add in Crell and Henry and Herne Bay and Hutton. So far, 5 must-know cases on frustration. So there are really only perhaps 2 more to go. And with all of those cases, everybody, you've covered pretty well everything you would need to know to answer any question in the exam on frustration. But remember, frustration is raised as a defense to a claim for breach of contract. So before we go tonight, don't forget the definition. Frustration occurs when, without fault of either party, performance of a contractual obligation has become either impossible, as in Taylor and Caldwell, illegal, as in Avery and Bowden, remember where war broke out, or radically different, as in Hernbay and as in Krell and Henry, contrast Hernbay and Hutton from that which was undertaken by the contract. And in Davis Contractors and Fairham itself, the obligations under the contract were not radically different. All right, you've got to pay 40% more, different, yes, but not radically different. Okay, there's the definition, everybody. Our last must-know definition in contract law. You've got them all now: offer, acceptance, consideration, exemption clause, misrepresentation, frustration. Must know those definitions, must know them word perfect, but understand what they mean and understand where they fit in. Frustration is raised as a defense to a claim for breach of contract. Okay, and we're going to look at the effects or the remedies for frustration. Not tonight. We'll look at those when we meet again on Thursday. So on Thursday, we'll complete termination of a contract, and then we'll get on to Chapter 5, which is looking at remedies for breach of contract. Okay, well, thank you very much, everybody, for your attention tonight. Well done. And go and have your hot cocoa now before you go to bed. Thank you once more for the birthday greetings. Well, what a lovely way to spend my birthday. Well, everybody says teaching is medicine for me. Well, there you go. Sometimes medicine doesn't taste. Anyway, it's great to be able to contact you, albeit online, and I certainly hope that we can meet face to face before we end this. Okay, there you go, Aussie Dave. Well, heaven's sake. Thank you, and well done. Thank you very much, everybody. So we meet again on Thursday. So read ahead, make sure you're up to speed, and we shall finish off termination of contract, particularly frustration, and get on to remedies for breach of contract. Okay, thank you very much. I'll see you all on Thursday.